Hi, good afternoon if you're on the East Coast, and good morning if you are out west. You are listening to an examination of the U.S. Department of Education's new Bar Defense Rule, Part 1. We're actually doing a session today and another session tomorrow. And today we're going to be talking about the Bar Defense Claim Framework. My name is Aaron Lacey. I'm a partner and practice leader of the higher education practice here at Thompson Coburn LLP, which is a big law firm based in St. Louis. And a lot of you know, I think, we have offices in other places like D.C. and L.A. and Chicago, et cetera. And our higher education practice really focuses on a lot of different issues, but among them are the rules and regulations issued by the U.S. Department of Education, and that's what we really want to get at today because there's a new one, and there's a lot to think about. Before I get going, the last time I did one of these, I totally forgot our housekeeping script, so I don't want to I would say get yelled at. That's a little unfair, but I don't want my producer to be unhappy with me. Let me put it that way. So let me make sure I get to this stuff. If you have any questions during the webinar, you can submit them through the Q&A widget on the bottom of the screen, and I will try to get to those at the end. And if you've listened before, you know I try to get through as many as I can. A copy of the slides is available. We often get this question. It's available right now, actually, in the Resources widget at the bottom of the screen. So if you want to go in now or later or after the presentation, you want to download the slide deck, you are very welcome to do that. I will also just note now there are some active links at different points in the deck. So if you pull those down, then you can click on the links and potentially get to other resources as well. You can find answers to some technical questions under the Help widget at the bottom of your screen. If you're a lawyer and you're tuning in for continuing legal education, CLE, this webinar is approved for CLE in Missouri for 1.8 hours and for general CLE credit 1.5 hours in California and Illinois. We award that CLE based on your attendance for the entire 90 minutes. So from time to time you will see a little pop-up thing that'll jump up on your screen. You just need to click it and let us know that you're still there and haven't walked away. We very much value your opinions and your feedback. So you'll see there's going to be a survey included at the end. If you would fill out that survey and give us your feedback. We try to make every one of these better than the one before, and we do read all your comments and really appreciate them. In fact, to that point, I will note one of the comments we frequently get is, boy, Aaron goes really fast and he covers a lot of content. So that's part of the reason we decided to break this into 2 days, today and tomorrow, and to do 90 minutes a session, is because I'm going to do my best to channel the central Louisiana boy and slow down a little bit as opposed to the D.C. regulatory attorney. So I'm going to try to go at a more deliberate pace today. We'll see if I'm successful. Please, you're welcome to give me your feedback and your thoughts. Finally, if you are listening to this on demand, all of our webinars, including these that we're offering today and tomorrow, we always post, usually within about 48 hours. They're available on our website, and I'll talk about that again later at the end just to make sure folks know where they can get to them. But just keep in mind, if you're listening to this 2 or 3 or 4 months later, you know, it's always possible that rules or law have changed or that there's new guidance that has come out, and you just want to be mindful of that. Okay, so with all of that having been said, let's get going. I mentioned my name is Aaron Lacey, and I've talked a little bit about our higher education practice. We're focusing today on the U.S. Department of Education's new Bar Defense Rule, which, by the way, some of you may know, the official version of this new final rule actually hit the Federal Register today. So if after the presentation or even now while the presentation is going you want to go out and Google it, it should pop right up. In addition to regulatory counsel around federal rules, we also cover state crediting agency laws, standards, discrimination law, things along those lines. We do a lot of work in the transactional space, helping institutions of all types, private, nonprofit, for-profit, and public, that are going through different types of sort of institution-level substantive changes, merger, acquisition, consolidation, you name it. And we do a lot of policy and compliance work in addition to litigation and representing schools in front of regulators and other issues. You know, the only thing here I'm going to really highlight, for those of you who may not know, in 2018, I was actually one of the folks appointed by the department to go to D.C. and to try to negotiate this rule that we're talking about today, and to give the Department of Education some thoughts about how we, at least on this side of the table, meaning institutions of higher education, feel like this rule and the process that we're going to discuss ought to play out. And while I was there, sort of my official capacity was negotiating on behalf of general counsels, attorneys, and compliance officers, which, of course, makes pretty good sense. Here's the outline. So I want to talk a little bit at the beginning about the bar defense rulemaking process and walk us up quickly, briefly, briskly, to how we got to where we are right now. And I know some of you who've listened in before, and if you've heard me speak on other platforms or for other associations, et cetera, on this topic, may have been through some of this. But we're talking today about the claims process and the way that the claims process is going to work on a go-forward basis. Is a little unusual and in my mind a little complex because what we're going to end up with, and you're going to hear me say this lots of times, essentially we're going to get to a place once this rule becomes effective where we have three different claims processes, right, or claim standards that are all sort of in play at the same time. And so I think it is particularly important when talking about this aspect of the bar defense rulemaking to walk up through that history and see sort of how things evolved and why we got to where we are. And I think that gives a lot of important context when we get into the nitty-gritty of the rules and the claims processes themselves. I will go ahead and promise you all, if you're planning attending again tomorrow, I will not do this a second time. So I'm just going to do it once today, and tomorrow when we talk about financial responsibility reporting and close school discharge and some of those other issues, we'll just skip right into it. Okay, so we're going to first talk about how we got here, and then we're going to break down BDR-1, BDR-2, and BDR-3. And again, you say, Aaron, why are we talking about the old versions of this rule? Because while we have a new rule and a new claims process that's going to be in place, again, as of July 1 next year, we're actually going to have three different standards and processes that are sort of in play all at the same time. And, my objective today is to help you understand come July 1 of next year what the lay of the land is going to be. And to really get that, you've got to appreciate all three of these different frameworks and the fact that they are going to coexist simultaneously. The bar defense rulemaking. So the origin story, and again, we're focused right now on the discharge process, but this whole thing started back in '93 when we had the direct loan program come along, and as part of that legislation, Congress told the department, they said, look, we appreciate that there could be circumstances where we're asking a borrower to pay back a loan, and the borrower feels like the school did something, whatever that might be, and that justifies the borrower not having to pay back the loan. So Congress said to the Department of Education, you tell us, whatever that act or omission might be on the part of the school, what is it that a school could do that would justify a borrower not having to pay back the loan? And that essentially is the borrower's defense, right? So the borrower, in the context of that type of proceeding, would assert a defense as to why they don't have to pay their loan back. So the following year, the department obliged and issued a regulation in '94, and they said, okay, so a borrower defense claim, it's any act or omission by the school that was attended by the student that would give rise to a cause of action against the school under applicable state law. So, if a school did something that violated the law of the land, or at least the state law, and the student could show that, the borrower could show that, then they wouldn't have to pay back their loan. Of course, it does raise the question, well, what state law are we talking about? I mean, are we talking about the state where the school is located? Are we talking about, in the modern context, particularly if you have online education, are we talking about the state where the student is located? Is it the state where they are a resident, or maybe the state where they are physically sitting while they're taking an online class? There are a lot of complexities when you start getting into this. And then you say, well, who at the department is actually making this call? I mean, is there a staffer there sitting over in D.C. who's going to have to look up the state laws that were in place 10 years ago and try to make a decision as to whether or not whatever the borrower is asserting actually represented a violation of state law? You can already see, I'm clearly foreshadowing here, but you can see why this standard was problematic. Understanding that there could be a little more meat on the bones, the next year the department did offer up a notice of interpretation where they said, look, well, let's at least draw a little bit of a box around what qualifies as a bar defense claim, and the easy way is to say at least what are some of the things that clearly would not. So they said, first of all, whatever the borrower is asserting, whatever that act or omission was by the school, it does have to relate to the loan or the school's provision of educational services. So if someone says, well, I shouldn't have to pay back my loan because I slipped on the sidewalk, like a tort claim, or if their allegation has something to do with sexual or racial harassment, the department said, look, those may be wrongs and you should be able to address those wrongs, but they're not a basis to discharge your loans. There's another place that you would go to bring that up and to try to seek some sort of resolution with the institution. The department also said at that point, we don't have any formal process for adjudicating these, but we acknowledge that schools should be entitled to some due process. In other words, a school should get a crack at telling their side of the story. And that was where they left it, right? And for 2 decades, between 95 and 2005, and really even after that, that framework was sufficient. I've heard lots of different numbers, but the understanding is, the number of claims that came in over that 20-plus year period was probably, if not single digits, low double digits. Then Corinthian collapsed, right? The school group out on the West Coast, for-profit school group, and the landscape dramatically changed. According to the department's data, they had over 118,000 claims filed by November 2017, and that represented, if all those borrowers' loans were discharged, you're talking about billions of dollars, right, in potential discharge. So the department appreciated, looking back, and this is the prior administration, the Obama administration, said, look, we've got this wonky standard about giving rise to a claim of action under state law. It's incredibly hard to enforce. We have no process on the books for how this thing's supposed to be adjudicated. We've only acknowledged that schools ought to have due process, and presumably borrowers should too, but there's nothing that spells out how we're going to go about adjudicating these claims, so we need to create a rule, right, to get in front of this and to start working through all these discharge applications. So in 15 and 16, the department carried out, this is the prior administration, a negotiated rulemaking to create what I'm going to call, for the purposes of this presentation, BDR-2. So that 1995 standard, the very first thing that the department came up with on the prior slides, giving rise to a cause of action under state law, that's BDR-1. And what the Obama administration crafted in 15 and 16, I'm going to call BDR-2. And the new rule we're going to get towards the end of this year, I'm going to call, or next year that becomes effective July 1 of next year, we're going to call BDR-3. Okay. So when the Obama administration went to the drawing board and they said, we want to come up with BDR-2, one of the other things I want to highlight is they just said, we're going to do a rulemaking, but we're going to go beyond just thinking about a claims process and the discharge process, and we're actually going to look at a lot of other things. We're going to look at revising financial responsibility. We're going to look at the use of pre-dispute arbitration agreements. We're also going to revise the regulations that govern closed school discharge, false certification discharge, and then we're going to revisit a couple other things, the definition of misrepresentation, and maybe imposing yet another repayment rate on schools. The prior administration, and for that matter, all of the regulatory community in higher ed, as you all know who are at institutions, has been very enthusiastic about outcomes and calculating outcomes and requiring institutions to disclose calculated outcomes, and that encompasses a wide range of outcomes from repayment rates and graduation rates and completion rates, success rates, and also different mechanisms for getting them out there. So this was sort of part and parcel with that whole movement that I would suggest started, probably about 10 years ago. So you had BDR-2 had this expanded scope, right? And they were going to talk about all of these things. Now, we, just to keep life simple, still tend to refer to all of this as the bar defense rulemaking, but keep in mind, again, we're talking about a lot more than just the discharge process. And I'm going to talk about a lot of this other stuff tomorrow, because many of these things are still on the table and we're still part of BDR-3. But at this point in time, so the administration, 15 and 16, pulls folks together again at the table in D.C., and they craft this new rule. They did not get consensus, which, as those of you who are familiar with negotiated rulemaking know, means that the department then was free to sort of promulgate a proposed and final rule that they liked, and they weren't bound by any decisions that the negotiated rulemakers had made. This new BDR-2 rule was published November 1st, 2016. And set to become effective July 1st of 2017. Then, on January 19th, 2017, and this is an important point, the department issued some supplementary BDR-2 procedures governing recovery actions, and those became effective immediately. Let's break this down in a second. So first of all, what do I mean by recovery actions? So the discharge process we're going to talk about today is the process by which the Department of Education would review an application received from a borrower, receive input from an institution, and then decide whether or not to discharge the borrower's loans. And that's what I'll call sort of the claim process or the discharge process. But if the department decides to discharge loans, then they subsequently have the opportunity and will, and in fact are directed under statute, to pursue recovery of those discharged amounts from the institution, right, that committed the act or omission that was the basis for the discharge. That recovery process was not spelled out in BDR-2 and frankly wasn't discussed in BDR-3. Interestingly enough, it was just sort of hanging out there and there wasn't real clarity around it. So the department in January of 17 decided to augment Subpart G, 34 CFR 668 Subpart G, which deals with fine limitation, termination suspension proceedings, to augment that and to include a section that talks about how the department would go about recovering monies from an institution when a discharge has already been made, right? So you got two processes. The first is the discharge of the loans. The second is the recovery action against a school. And what's interesting, again, is you've had three rounds now, BDR 1, 2, and 3, all sort of around how we go about discharging the loans. But the recovery action, we got those rules January 19th of 2017, and they're on the books and are not and have not been changed. They weren't really negotiated during BDR-3, and they haven't been materially changed by the rule that's going to go into effect July 1 of next year. What's interesting, by the way, I don't know if you know if that date has any meaning to you right away, January 19th, it was the day before the current president was inaugurated, right? So this was literally an 11th hour promulgation of a new rule. Okay, so the very next day, January 20th, we get a new president and we get a new U.S. Department of Education. And in 1718, the new administration said, you know what, we're going to delay almost all of BDR-2, pretty much every piece of it, until July 1, 2019 at least. And we're going to carry out a new negotiated rulemaking to create yet another version of the bar defense rule. And so they did that, and that was the process I participated in that I referred to earlier. So we showed up in D.C. in late 17 and early 18, and a bunch of us sat around a table and tried to give the department a lot of feedback about how we thought a better rule could be created. Consensus was not achieved, once again, and then a proposed BDR-3 rule was published July 31st, 2018. So a lot of us in the regulated community anticipated that a final rule, subsequently, there would be a comment period, and then a final BDR-3 rule would be published by November 1st, 2018, which would have allowed it to become effective this year, July 1st of 2019. And then a lot of things happened. I have to tell you, as a regulatory attorney in the space, this has been a very useful slide to me in the last couple of years. So there was sort of a blow-up, right? In an order dated September 17, 2018, right, the District Court Judge Randolph Moss, first of all, found the current administration's effort to delay BDR-2 to be unlawful, right? Simultaneous to the expiration of this 30-day window, there was a lawsuit out there, some of you are familiar with, by the California Association of Private Post-Secondary Schools, challenging BDR-2, and Judge Moss, throughout their ability to enjoin, or throughout their effort at that point to enjoin certain elements of BDR-2. So the lanes were totally cleared, right? First of all, the current administration's delay was rendered or determined to be unlawful, and then the CAP's effort to enjoin BDR-2 was also thrown out. Okay, so as a consequence, the path was cleared, and this bar defense rule that was supposed to become effective July 1st, 2017, and then delayed, was deemed to be effective. Now, I want to be clear, that event occurred on October 12th, 2018. Honestly, the wording here is probably not as good as it could be. But the rule, even though the judge said, okay, the rule is now effective as of October 12th, 2018, that's the day the judge said it, it was considered to be effective from July 1, 2017 forward, right? So BDR-2 right now is the law of the land. And it is considered to have been the law of the land since July 1st, 2017. To the surprise of many, the department did not make that target, right? Meaning that BDR-2 would become effective for at least 18 months, right? That's what we knew at that point. And then there was this several-month period that went by where everybody was sort of saying, well, okay, BDR-2 is in effect, but what does that mean? Like, how do we implement it? And finally, on March 15th, the department affirmed that BDR-2 was in effect and released some fairly significant guidance regarding how to comply with it, because you had this rule that, you know, nobody was complying with on July 1st, 2017, and almost a year later, you were suddenly told, well, you should have been complying with it since July 1st, 2017. And so the regulated community said, well, okay, how do we do that? And the department in March of this year said, well, here's some guidance on how you can sort of, what you need to do to look back with regard to things that may have happened since July 1st, 2017 to now, and then how you need to conduct yourself on a go-forward basis. By the way, there was some additional guidance the department put out on June 3rd, and then again on June 19th, and I don't know a lot of people caught the June 19th. The department put out this Q&A on June 3rd. They had an electronic announcement, and you can access the Q&A electronic announcement, and there's an attachment, a PDF attachment. What many people probably are not aware of is that the department subsequently updated that PDF attachment and added some new Q&A dated June 19th. So if you haven't gone back since June 3rd and pulled that PDF, you should do it. And then on September 23rd, 2019, today, the department published its new final BDR-3 rule, right, with an effective date of July 1st, 2020. I'm not going to go through the whole timeline. This is what we just talked through, but what I've provided for you here, you got two slides, and it's got all of the events I just discussed, plus some additional, and then links to underlying documentation, right? So I talked about the notice of interpretation, proposed rules, final rules, etc. You can find those if you follow these links. They're out there online. I've also included here, if you look down at the bottom on this slide, June 3rd, 2019, I've got a link to the new Q&A document I mentioned that has the updated information for June 19th. And then for September 23rd, we have a link to the new Federal Register that just hit today. I will confess, it actually became available over the weekend. That's how I was able to embed the link. But it is out there, so you can now get a PDF of the official publication in the Federal Register. Okay, so let's talk about the bar defense claim frameworks. And you know, so the question is, well, what do you mean, Aaron, that there are going to be three in place simultaneously? Here's the deal. So this administration did not say, as of July 1, 2020, all claims that come forward, without regard to, you know, when the act or omission may have occurred and the underlying loans may have been made, all claims going forward will be managed under the BDR-3 process and using the BDR-3 standard. They didn't do that. Instead, what they decided to do is they said, okay, we're going to leave in place BDR-1, that standard, and BDR-2, right? So if someone brings a claim, and I'm talking about next year, come July 1, 2020, if you have someone bring a claim, and the claim relates to the loans at issue that they're trying to discharge were first dispersed prior to July 1, 2017, they will still be adjudicated using that BDR-1 claim standard, right, which is, does it give rise to a cause of action under state law? And some staffer at the department is going to have to try to figure that out. And interestingly enough, the department also allowed, and this was something that the Obama administration, under their BDR-2 rule, created. When the Obama administration came up with BDR-2, they actually did change some of the language for BDR-1. And they said, okay, if someone brings a claim, even if it's under the BDR framework, and the loan was first dispersed prior to July 1, 2017, it will be adjudicated using the process set out under BDR-2, right? I know this is getting confusing, all right? Just stick with me. I'm going to go through this all again, and we're going to talk about it in additional detail. But so let me be clear. Let me just try to give you an example. So if, you know, next year in November, you have a borrower who decides to bring a claim, assert a claim, and they say, you know, my institution did something wrong. And then the department gets the claim and they say, okay, the underlying loans that they're trying to discharge, those loans were first dispersed prior to July 1, 2017. Then what the department's going to have to do is they're going to apply the BDR-1 claim standard. They're going to ask, okay, did the act or omission by the institution that you're alleging give rise to a cause of action under state law? And then when they go to adjudicate that claim, right, you talk about the process that they're going to use back and forth, working with students in the school to the borrower in the school to get information, et cetera. They're going to use the process articulated under BDR-2. And that will be the case forever, right? as long as the statute of limitations has not run on a borrower being able to bring a claim, I'll talk about that in a little bit, but for as long as the borrower can still bring a claim, if the underlying loans were dispersed prior to July 1, 2017, they'll be using the BDR-1 claim standard and the BDR-2 process, period. And this administration, in creating this new rule, did not change that. So what if somebody brings a claim next November and the loans that they want to discharge were first dispersed on or after July 2017, but before July 1, 2020? Then they will be under the BDR-2 standard. And I'm going to talk about that. So it's not whether or not it gives rise to a cause of action or state law. There's a new standard, the BDR-2 put in place, a federal standard. It involves misrepresentation, breach of contract, et cetera. And that'll be the standard, and they'll still use the BDR-2 process. Let me say that again. If someone brings a claim next November and says your school did something wrong, there was some act or omission that occurred, and the loans they are trying to discharge were first dispersed between July 1, 2017 and July 1, 2020, then that claim will be adjudicated using the BDR-2 standard as to what constitutes a BDR claim and the BDR-2 process. So what that means is, and again, this administration in creating the BDR-3 rule didn't change any of that. What they essentially did was they left the entire rule as crafted by the prior administration in place. And what that also means is, and I want you to try to wrap your brain around this, right now, every loan that's ever been dispersed to date has been dispersed prior to July 1, 2020, right? So the entire outstanding loan portfolio, federal loan portfolio that is out there right now, if any borrower brings a claim that involves any loan that has ever been made to date, it's going to be adjudicated using either the BDR-1 or BDR-2 claim standard, and they will all be adjudicated using the BDR-2 process. And that will not change when this new rule goes into effect next year, right? So let me just say that again. Every loan that's ever been made, if somebody brings a claim, even after July 1 of next year, for every loan that's ever been made, it will be used using the BDR-1 or BDR-2 standard, depending on the time frame, and they will all be adjudicated using the BDR-2 process. Okay? So some folks may say, well, why would they do that? Right? Why would they do that? Why would they say that only loans that are dispersed after July 1, 2020 will be under the new rule? Politics, right? I mean, I'm speculating. I haven't had conversation with the department about this, but, you know, every rule that the U.S. Department of Education has promulgated, this administration has promulgated, pretty much they've been sued over, right? The Title IX rule, they're going to get sued over, you know, elements of it. They've already been sued over trying to delay the guidance from last year. State authorization, they got sued. Bar defense, they got sued. Gainful employment, they got sued. I mean, they know, right? These are the times we live in. So they are trying to come up with a bar defense rule that can be defended. And if they go and augment, I mean, the headlines, if you read the headlines right now, or you listen to some of the political statements out there, I mean, everybody says, oh, the bar defense rule has been totally gutted and all of these students have lost rights. Well, the rights and responsibilities of students, when you talk about loans dispersed after July 1, 2020, are going to change as compared to what they are right now. But for every borrower that exists right now who has received a loan, their rights and responsibilities when it comes to discharge is not changed. It's going to be adjudicated using the rules that the Obama administration put in place, right? And you know, my speculation is that the department took that view, this administration, and they didn't try to revise all of that because they wanted this rule to have better legs and they wanted to be in a better position to defend it, and they didn't want somebody saying, you know, you sort of retroactively went back and tried to change things and you actually caused, in some way you diminished the rights of folks by passing your new rule. So that's why they did it that way. But this is why it's so important for folks to understand what the BDR-1 standard is about and the BDR-2 standard is about, right? Because they're not going away. They're going to continue to be used for years to come until the statute of limitations completely run, and that's going to be a long way out. Okay, so let's talk about these three standards. We got 1 hour to do it. By the way, just talking about claim volume, this is a nice slide Nicholas Kent over at CQ put together and allowed me to use based on departmental data. So this just gives you a sense of the increase in the volume out there. And the real reason I put it here in the presentation is because I just wanted, again, tying to the statements I just made, to accentuate that all of these claims that are out there the 240,000, all will be adjudicated using either the BDR-1 or BDR-2 standard and using the BDR-2 process, right? Okay, so let's talk about the BDR-1 claim framework. Now, in going through, what we've already talked about, we hit on a couple of these things. First of all, affirmative claims are allowed in all three contexts. And what I mean by affirmative claim, there was some discussion in the proposed rule for BDR-3 and previously that, around whether or not borrowers should be able to assert a defense or at least make a claim outside of the context of a proceeding. In other words, the statute says a borrower can, the statute seems to contemplate if the department is trying to recover from the borrower on the loan, then the borrower can assert this as a defense in the context of that proceeding. So then the question became, well, but do we really, does a borrower have to actually go into default if they feel like their school has done something wrong? Shouldn't they be able, without defaulting on their loans or otherwise being in the context of some recovery proceeding with the department, shouldn't they be able to sort of affirmatively file an application? And most folks in the community, including on the institutional side, by the way, at the table at BDR-3 and I think in prior rulemakings, just about everybody was in agreement that it should be permissible. I mean, that was a position I took when I was at the table, right? And I know a number of the trade associations that represent institutions also said, we agree. We don't think somebody should have to necessarily go into default, et cetera. Let them file an application if they think the school did something wrong. Of course, that means it's very important that the subsequent process be fair to both sides, including institutions, and that the schools have an opportunity to defend themselves. So BDR-1, 2, and 3 all allow for affirmative claims. For BDR-1, we mentioned we're talking about when the claim involves loans first dispersed prior to July 1, 2017. By the way, somebody's going to ask if they haven't already, what if a student brings a claim and they've got loans that cross over these periods? I don't have an answer to that. The department presumably will have to apply the appropriate standard and the appropriate process depending on when the loans were made. If the student's actually carrying underlying loans that fall into different buckets. Now, if it's a consolidation loan, which pulls everything up into a latter period, I think it would be based on the date of the consolidation. And there's some language in that in the preamble and where the department has contemplated that possibility. But if you sit down and start thinking about, you can come up with a lot of sort of interesting scenarios where either the underlying loans differ or you've got an act or omission that affects two different students, the same act or omission. Somebody said something on date X, and the first student has loans from a prior period, and the second student has loans, on the other side of that. You can get into some sort of real head scratchers. And the bottom line is the department, when you get practical here, is just going to have to figure out how to work through all of that because you've got this sort of difficult situation where you've got multiple standards that you're having to deal with, and you've got persons who could cross over from one bucket into another. Okay, so BDR-1, again, accepts affirmative claims. The claim standard, remember, what is a BDR claim under BDR-1? Act or omission must give rise to a cause of action under applicable state law. There is no evidentiary standard articulated in the BDR-1 regulation. You see down here in the bottom right, 685-206C, but it's preponderance of the evidence for BDR-2 and BDR-3, and my expectation is that the department will use a preponderance of the evidence standard if adjudicating a matter in the BDR-1 bucket as well. And what that means is, when the department's evaluating the evidence and the application that a borrower has provided, the other documentation they may have had on hand, to decide whether or not they think that act or omission really occurred, right, they're going to have to reach a determination that it's more likely than not, based on the evidence they have available, that it did occur. The claim process, again, I mentioned a moment ago, even if it's a BDR-1 claim, so involves a loan before July 1, 2017, it's going to be resolved using the BDR-2 procedures. That's explicit in the regulations, and that was not changed. So that will not change on the other side of July 1, 2020. In other words, again, this administration didn't change that mechanic. Which is interesting, because in my mind they could have, right? They could have said we're still going to use the BDR-1 standard when it's in the one bucket, the BDR-2 standard in the other bucket, but we're going to adjudicate all of these claims using the BDR-3 process. And they didn't decide to do that. They said, no, we'll still let them stick with the BDR-2 process. Time limit for claims. So a borrower can assert a defense at any time if you're talking about loans dispersed prior to July 1, 2017. In the regs, there is no statute of limitations. However, there is a time limit on the department for when it can recover. So the department can initiate a recovery action the later of 3 years from the borrower's last award year, or that state law statute of limitations, unless the school received qualifying notice of the claim. So what's going to happen, and I'll get to this idea of qualifying notice in a second here, because that's a significant carve-out. But, setting that aside, there will come a point where all of the state statute of limitations have run, and all of those borrowers who have loans first dispersed prior to July 1, 2017 have been out of school for more than 3 years, right? And at that point, the ability to file a claim under BDR-1 will start to diminish greatly. And you'll see, less confusion because fewer and fewer borrowers will have the availability to bring a claim under BDR-1. Now, what about this carve-out for qualifying notice? So school has notice if it's received actual notice from the borrower or a borrower representative of the department. So even if the borrower hadn't filed a claim yet, if they've literally given notice to the school that they've got an issue, then the department's saying, okay, well then the statute of limitations hasn't run yet. A class action complaint that could include the borrower and similar facts, right? So in other words, if there's a class complaint but the borrower is part of the class and it's the same type of allegation, essentially the school is on notice. And then finally, written notice. And this can include a CID or some sort of written demand for information from a federal or state agency where they're investigating the matter. The idea here is, by the way, just so you understand mechanically why this works the way it does. I mean, part of the reason you have statute of limitations is because, in whatever context, in this context it's an institution that typically, right, would be the defendant, so to speak. The idea is there comes a point where institutions no longer have these records and they've gotten rid of them in accordance with, the department and everybody else is telling us don't hold on to records any longer than you have to because of fear of cybersecurity issues or data breach. So, organizations and institutions get rid of records, and the idea is there comes a point where they no longer have the personnel or the records available to adequately defend themselves. And so a just conclusion is unlikely. And that's sort of philosophically the basis for having a statute of limitations. So here, what the department is saying is, well, look, if any of these things had occurred, if you had actual notice or there was a class action complaint or a government investigation that basically alleged the same wrongdoing prior to that 3-year statute of limitations running. In other words, the school was already on notice that there was an issue, and they likely are already keeping the records and preparing to defend themselves. So the department should still be able to initiate a recovery action. That's sort of the concept, right? Okay. So BDR-1 is actually pretty simple. BDR-2 is less simple. There's a lot to this one. This is the one that the Obama administration crafted. It's got a lot of different parts, and I do want to spend a little time talking about it because, again, all of those loans out there are going to be, every loan that's ever been made to date will be adjudicated using this process under BDR-2, right? You won't get into the BDR-3 process until you start dealing with loans that have been dispersed after July 1, 2020. Okay. So how's BDR-2 kind of look from 40,000 feet? Again, affirmative claims are allowed, and we're talking about when you're asking yourself which claim standard applies, we're talking about loans dispersed on or after July 1st, 2017 and before July 1st, 2020. When you're talking about which process, adjudication process applies, you're talking about everything dispersed before July 1, 2020. Because remember, in all cases, BDR-2 will apply if the loan was dispersed, underlying loan, before July 1, 2020. So what's the standard under BDR-2? Well, there's 3 of them. There's if the borrower can show that they have a judgment out of a state or federal court, if they allege a breach of contract or substantial misrepresentation. I'm going to touch on those in a minute. The evidentiary standard, again, is preponderance of the evidence. The claim process is actually very complex. There's an individual claim process, and then there's a separate group claim process that differs based on whether the school is open or closed and includes this presumption of actual reliance. We'll get into this in a minute. Time limit for claims, also complex. It's tied to the statute of limitations and whether there was a notice of the claim. The same is true for when the department can bring a recovery action. So many of these components are far more complex than what you see under BDR-1, and for that reason, we're going to break them down here and just revisit them for a second. So under BDR-2, a claim, a bar defense claim, you still have to show that the act or omission, a borrower would have to show that the act or omission related to the making of the loan or the educational services provided by the school. So again, slip and fall, sexual misconduct, racial discrimination, those kinds of things would not be the basis for a BDR claim under any BDR 1, 2, or 3, right? In addition to having this act or omission that satisfies these one of these two elements, a borrower would also have to show that the act or omission was the basis for a judgment against the school, was a basis for a breach of contract, or was a substantial misrepresentation. Let's break each of these down. So what do I mean by judgment? So we're talking about a non-default, favorable, contested judgment secured by a borrower or a government agency, by the way, or a government agency, based on state or federal law in a court or administrative tribunal of competent jurisdiction. So basically it's already been litigated, right, in a sense. And at this point, the borrower is showing up to the Department of Education saying, look, I already got a decision by a competent court or administrative tribunal that the school did what I'm alleging they did. And in that case, the department says, you know what, there's no statute of limitation. Someone can show up at any point in time, whenever, really, I mean, there's no limit at any point in time. If they've got a decision that shows that the school, you know, engaged in the act or omission, they can show up and make the claim for the discharge of their loans. What about breach of contract? So here the department's saying, okay, student shows up, act or omission relates to the educational services you provide, and also constitutes a breach of contract. What do we mean by breach of contract? It includes any failure to perform under the terms of a contract with a student without regard to materiality. So there's nothing in the regulation that says, well, when we say breach of contract, it has to be of a material term. It just says breach of contract with a student. And the prior administration, when they promulgated this rule, indicated in the preamble that a contract could include an enrollment agreement, any school catalogs, bulletins, circulars, student handbooks, or school regulations. So for my private nonprofit friends on the line who don't use an enrollment agreement, I want to be really clear, the prior administration was not limiting this idea to the breach of an enrollment agreement, which is more common among career schools. They were envisioning that you could have a contractual relationship with a student very much at a private nonprofit or public institution, and that contractual relationship could be formed again by a student handbook or school regulations, right? So, you know, you've got obviously large private nonprofits or even small ones that have lots of policies and documentation and handout that they give to a student, and you would be in a position of having to argue to the department that that does not create a contract. Now, some of you may say, yes, does this administration take that view? I don't think they do. I think they probably would take a more limited view, and I think there's a reason when we talk about BDR-3 in a minute that breach of contract doesn't show up in BDR-3, and they've talked about and why they eliminated that. But keep in mind, BDR-2, this framework, is going to continue to exist after July 1st, 2020. And next year you could have an election, and you could have a new administration and a new Department of Education, and they may take a view of BDR-2 and the enforcement of BDR-2 that is more consistent with the prior administration, the Obama administration. So in other words, 2 years from now, you could have a staffer at the department adjudicating a claim under the BDR-2 framework who agrees with this, right, and says, yeah, there was a breach of contract. That's a valid basis for a claim under BDR-2. You know, here the student is saying that you had something in a circular or your catalog and that you breached that contract. So that's a valid basis for seeking a discharge of their loans. Time limit for claims, there's no limitation on claims to discharge future amounts. So if a student's got a 20-year loan term, right, and they're 14 years out, I mean, they can still bring a claim if when you're talking about trying to discharge those amounts they haven't yet paid, the remaining 6 years. There is a 6-year limitation on claims to discharge amounts already paid, and that's from the date of the breach, right, or from the date that they reasonably should have known of the breach, right? So it differs a little bit. Like I said, there's a complexity there. It depends on whether they're trying to discharge future amounts or amounts that they've already paid to the department. What about the last bucket, substantial misrepresentation? So this includes any substantial misrepresentation made by the school or any contractual partner. I want to emphasize that second piece, or any contractual partner. So all those vendors you have relationships with, right, who may be speaking to borrowers or the public on your behalf, they can also be covered if they make a substantial misrepresentation, right? And all the other pieces are in place, and the student can show that, or the borrower can show that it impacted them, right, to their detriment. It doesn't matter whether they were an employee of the school. It could be a vendor as well. The borrower has to show actual reasonable reliance to his or her detriment. Now, they don't have to show that the detriment itself was material, right? So it could, I mean, if they actually reasonably relied on the substantial misrepresentation and it cost them $10, in theory it's still the basis for a discharge under BDR-2 because there's no materiality concept attached to detriment. There's also a presumption of reasonable reliance in group claims. I'm going to talk about group claims in a minute, but if the department initiates a group claim, which is sort of like a class action, right, then and the basis for the claim is a substantial misrepresentation, in that case, then there is an assumption, right, that, or presumption rather, that the members of the class reasonably relied on the substantial misrepresentation, and the school would have to rebut that. So it's a rebuttable presumption. But the class action concept, in that context, the department doesn't actually have to show that everyone individually relied on the substantial misrepresentation. There's no limitation on claims to discharge future amounts, and again, a 6-year limitation on claims to discharge amounts already paid, and that's from the date the bar discovers or could reasonably discover the misrepresentation. Now, some of you are saying, if you've not followed our prior presentations or you're new to this rule, well, substantial misrepresentation sounds like a pretty high threshold. I'm here to tell you it is not, right? At least if you're a lawyer type like me and you're into risk mitigation and allocation, this definition is frightening from an institutional perspective. And a lot of schools who have been following this know, because under the BDR-2 framework, the department just decided to bootstrap and use the existing definition of misrepresentation that exists elsewhere in the law. And that definition of misrepresentation does not include any concept of intent or negligence or anything along those lines. It's just if you said something that has a tendency to deceive or could be determined to deceive, it's a very low threshold. Right? And a substantial misrepresentation, which is also in the law is defined, just means any misrepresentation on which the person to whom it was made could reasonably be expected to rely or has reasonably relied to that person's detriment. So again, there's no materiality concept here around detriment. The idea is if there was some statement was made by the institution or contractor, right, that had this sort of tendency to deceive, right, even if it was inadvertent, or even if it was factually accurate but misleading, right? I'll talk about that in a minute. In either case, it could be considered a misrepresentation under the law. And if that misrepresentation, if that person could basically, even if they didn't rely on it, if they could have been deemed to potentially have relied on it, then that qualifies it to their detriment as a substantial misrepresentation. And again, the detriment doesn't have to be material. So if you're a lawyer type and you're really parsing these definitions, the threshold is pretty low. And let me just be clear, there is no question that the prior administration viewed this standard, the misrepresentation standard, as a mistake standard. In other words, even if the school made a mistake, they still felt like that could qualify as a substantial misrepresentation. And this is a quote out of the preamble or the commentary to BDR-2 by the prior administration. They said, "We believe that an institution is responsible for the harm to borrowers caused by its misrepresentations, even if such misrepresentations cannot be attributed to institutional intent or knowledge and are the result of inadvertent or innocent mistakes. Similarly, we believe this is the case even for statements that are true but misleading." So to be clear, you could have a vendor that inadvertently, mistakenly provided inaccurate information, and someone could rely on that to their detriment without regard to the materiality of the detriment, and that could be the basis for a loan discharge under BDR-2. All right. So again, if you're a lawyer type and you look at that sort of all put together, it's a little troubling. And this is one reason, frankly, this administration felt like they could do a better job designing standards that offered institutions a more balanced process, right? So BDR-2, the individual claim process. The borrower submits the application and evidence to the department, and then the department grants forbearance, suspends collection. The department designates staff to review and resolve the claim, and then the staff notifies the school of the claim at that point. The staff reviews the evidence and the records available to the department and any school submission, and then upon request, they'll provide the borrower with the relevant evidence to review. And then they issue a written decision and notify the borrower. And finally, if they want to, they can have a recovery action. Now, you know, I think a lot of people at first blush, you go through this and you think, well, that seems like a fairly reasonable process, but let me just flag some stuff for you. First of all, a borrower can request a reconsideration under BDR-2, under this framework. A borrower can request a reconsideration at any time based on new evidence. Or the department on its own can reopen a claim at any time to consider new evidence. And that's relevant evidence as determined by the department that was not previously provided or was not identified in the final decision as evidence that the department relied upon. So one of the concerns here is it seems like even after you get to the end of the road, the department has considerable discretion to continue revisiting potential determinations. But here's some other things to think about under BDR-2. First of all, there's no independent hearing official. In other words, this isn't an administrative law judge or someone outside of the department. It's a staffer, right, down the hall trying to make the call. The department's not required to supply the evidence to the school. So if it got evidence from the borrower, if it had other evidence on hand under BDR-2, they don't have to provide that to the institution. The school's not guaranteed a right to respond. There's no guaranteed time frame allowed to either party for the response. The department's not required to provide the school with the written determination. It says that under BDR-2, it says the department will provide the borrower with the written determination, but nowhere does it actually guarantee that the school gets a copy of the written determination. Presumably, you would have to get a copy at some point in order to go on with the recovery action and to defend yourself, but it's not in the reg. The school has no right to request a new review based on new evidence, just the borrower, and there's no appeal opportunity afforded to schools under the individual claim process. Right? So there are a lot of places where, again, lawyer types look and say, well, wait a minute, this seems like a significant problem from a procedural standpoint. And I think the BDR-3 rule and the process that this administration has put into place or will put into place as of July 1 next year tries to address some of these issues. But they still exist in the BDR-2 framework, and that framework is still going to be used for lots and lots of discharge claims. Okay, BDR-2, this is the group claim process for open school. I mentioned there's another process for closed schools, and it actually affords even less due process to institutions, but I'm not going to go through it. I'm just going to hit on this. So this is that class action concept that exists under BDR-2 and has not gone away. So, I'm doubtful that the current administration would make use of it, but I want to be clear, a subsequent administration in 2 years could still utilize this and initiate a class proceeding where all the underlying loans involved were first dispersed prior to July 1, 2020. So the department on its own can initiate on behalf of a borrower group a claim process, and they designate a staffer, so that's probably going to be someone in the general counsel's office, an attorney or someone on their side to represent them, and they notify the borrowers. The department then notifies the school of the claim and the proceeding and its procedural rights. A hearing official, in this case likely an administrative law judge, considers the evidence and argument from the department and the school, and then the hearing official issues a written decision. All the parties receive copies of the decision, and then the staff or the school, in this case, can appeal the decision to the secretary, and the secretary has the opportunity to issue a final decision. Once you get that final decision, if there is a discharge liability, the department can initiate that separate recovery action against the school. So, again, let's talk about some concerns. First of all, the department can reopen a claim at any time to consider new evidence. So even when you get to the end of the road, apparently the department could start a new class claim based on the fact that there's new evidence. And since they initiate the process, it seems like that gives them a lot of flexibility to just keep running it through. And this is sort of an extraordinary concept, if relief for the group has been denied in full or in part, a borrower can still file an individual claim based on the same act or omission. So in other words, if the department says the school did X, and they certify a class in a sense, and they run it all the way up, and an ALJ decides against the department, and then the secretary decides against the department and says, no, we don't think the evidence is there, we've looked at everything, then an individual borrower could then still turn around and file an individual claim that presumably would be adjudicated by a staffer at the department, to which there is no appeal right. I mean, this is sort of an extraordinary, in my mind, procedural snafu, and I think if this actually happens, you're going to see some sort of challenge to this. Other issues. The department's not required to provide the school with the evidence filed in support of the claims. There's nothing in the reg. The department's not required to identify to the school the evidence that it considers relevant. The school's not guaranteed a right to respond to the department, even in the group process. I'm not saying the department wouldn't give them that option, but the right to respond is not set forth in the regulation. There are no time frames specified for communications with the department or the ALJ. Presumably, if the ALJs operate the way they do now, they would probably create some sort of order governing proceedings and lay out time frames. But again, it's not in the reg. And while there's an appeal right guaranteed, there are no procedures. It just says you can appeal to the secretary. So we have no idea what that appeal would look like or how it would be carried out under BDR-2. Time limits for recovery action. So how long does the department have if you do see a discharge under the BDR-2 framework to then try to recover from the school? So forever, if the underlying claim was based on a judgment against the school, right? 6 years where the claims are based on a breach of contract or substantial misrepresentation. And they track those same statute of limitations that you saw earlier for borrowers to bring claims themselves. And at any time if the school had qualifying notice, remember we talked about earlier that qualifying notice. So if the school had notice before the statute of limitations ran, then the department basically has unlimited time to turn around and come after the school, even if the notice periods had expired. All right. So let's take a deep breath. We still have 35 minutes. And now let's talk about BDR-3. Right. So what is it that this administration is proposing should change when we're dealing with loans that have first been disbursed after July 1, 2020? This is the 40,000-foot view. Affirmative claims. So again, we allow affirmative claims, and we're talking about loans first disbursed on or after July 1st. We got a single claim standard. So after July 1, 2020, or at least when you're talking, I should be clear, when you're talking about loans first disbursed after July 1, 2020, the claim standard, the only standard, is going to be one of misrepresentation. The evidentiary standard remains preponderance of the evidence. Now a borrower has to show monetary harm. That's not required under BDR-1 or BDR-2, right? There is more effort and more clarity around what types of claims would not qualify as BDR claims. So the department has drawn a better box, I would say, around what constitutes a BDR claim after July 1, 2020. You have a much simplified process, which in my view is not perfect, but is easy to follow and includes some guaranteed time frames and things along those lines. Time limit for claims is simplified. 3 years from the date the borrower is no longer enrolled, right? So there's only one basis for claim, misrepresentation, and the borrower can bring the claim up to 3 years after they're no longer enrolled, whether they withdrew or whether they graduated. It doesn't make a difference. And the time limit for recovery action. So how long does the department have to come after a school? 5 years from the written notice of determination. So you don't have all this complexity that we see in the BDR-2 process. It's just flat standards. Okay, so let's explore some of this stuff in a little more detail. First of all, the claim standard. I've said there's a single sort of standard that revolves around misrepresentation. So the department will approve a claim if it's established by preponderance of the evidence that an institution, so in other words, this is the circumstance under which they would approve a borrower's defense, right? If it can be established by preponderance of the evidence that the institution made a misrepresentation of material fact upon which the borrower reasonably relied in deciding to obtain a covered loan, and the misrepresentation directly and clearly relates either to enrollment or continuing enrollment or the provision of educational services, and the borrower was financially harmed. So let's break this down a little bit. First of all, has to be a misrepresentation. There's no breach of contract, right? Now, if someone can show that a breach of contract or they show up with a judgment from a court that otherwise is a misrepresentation or demonstrates a misrepresentation, I mean, they could still satisfy this standard, to be clear, but they have to show it was a misrepresentation under the definition I'm going to show you in a minute here. It has to be a misrepresentation. It has to be of a material fact. Right? So if you know your team mascot tells somebody that the way to the stadium is through the gym, and it turns out that's inaccurate, right? First of all, that's probably not a material fact. Second of all, it would probably be unreasonable to rely on that information from the team mascot, right? So that's a ridiculous example. But the point is there are going to be representations that might be made that don't involve material facts and that a reasonable person would not rely upon because the entity or person making the representation is not a reliable resource, right? Again, the misrepresentation can't be of anything. It has to directly and clearly relate to enrollment or continuing enrollment or the provision of educational services. Now, it's still a lot. It still covers a lot of territory, but you're putting some parameters around it. And finally, to state a claim, again, a borrower has to show that they were financially harmed. Okay. So what about the standard or burden of proof. I mentioned earlier, I'm not going to spend too much time on this because I think there's already been a lot of conversation, but in this context, as well as in BDR-2 and I believe BDR-1, the staff is always going to be using a preponderance of the evidence standard. But the one thing I did want to highlight here is sometimes I've heard some of the consumer advocates and other folks express concern that it is extremely hard for a borrower to satisfy this standard, and there is some challenge there. I mean, the idea is that the borrower has to show up with some evidence, right? And what's interesting is the BDR-3 rule actually says, in the language, it says a borrower has to establish, but the rule also makes very clear, and that's the little sub-bullet I've got here, the department specifically states that the agency, quote, may consider evidence otherwise in the possession of the secretary, including from the department's internal records or other relevant evidence obtained by the secretary. So what's that mean? Well, what it means is when the department is deciding on the claim and they're evaluating all the evidence that they have at their disposal or in their possession, they are not limited to only looking at what the borrower provides, right? So if there was an attorney general investigation or a program review or an annual audit, or if 100 other borrowers have made the same complaint, then in addition to what the one borrower provides, because remember, under BDR-3, we only do individual claims, right? There's no class action, there's no group claim process. But if you got 100 borrowers who file a claim alleging the same act or omission, then when the department is evaluating the claim for purposes of borrower number one, the other 99 claims can be collateral evidence that the department has at its possession and it can refer to. They could also look at any evidence from a program review or an investigation or an audit that they may have conducted or another regulatory agency may have conducted. If there are public filings with a court that is available to the department, they may have those records. So even though the borrower number one may only have filed a single application that's a few pages long, the department ostensibly could have a significant amount of additional evidence that they're taking into account. So to say that the borrower alone has to satisfy this standard is really misplaced, right? The fact of the matter is the department has to be convinced based on the preponderance of all the evidence that is available to the department, which to go far beyond what that borrower has provided. That's what has to convince them that the claim has merit and that the underlying loan should be discharged. So I just want to make that clear. I mean, it's a really important distinction and something that's important for institutions to understand. Okay. What is the definition of misrepresentation? It's not, in this case, the definition that exists elsewhere in federal law. We've got a new definition of misrepresentation to be used specifically in the BDR-3 adjudication context. So in this case, the department has defined it as a statement, act, or omission by the school to a borrower that is false, misleading, or deceptive, that was made with knowledge of its false, misleading, or deceptive nature, or with a reckless disregard for the truth, and that directly and clearly relates to enrollment, continuing enrollment, or the provision of educational services. So this is a big difference from the misrepresentation standard under BDR-2, and I want to highlight this again because it could be counterintuitive. You know, when you look at BDR-2, what has to be shown is a substantial misrepresentation. And you hear that, substantial misrepresentation, and it sounds like it would have to be worse, right? But the devil's in the details. And as I mentioned earlier, the definition of misrepresentation and substantial misrepresentation being used under BDR-2 casts a much broader net, and the department knows that. Remember, the prior administration said, yeah, we know it casts a broader net and includes inadvertent mistakes or statements that might be accurate, truthful, but misleading. That's not the case here. This administration has said, look, we know what the prior administration said. We know the standard that's put in place with BDR-2, right? We're aware of that quote from the preamble. But we believe that institutions, right, or let me state this differently. We believe that if an institution says something that is true, or if they make an inadvertent or innocent mistake, that is not the basis for a discharge. Now, I want to be clear. This administration isn't saying that if the school makes a mistake and it harms a student, that the school shouldn't make it right, because the school should make it right, right? And hopefully everyone on the phone agrees and everyone out there in the community agrees. No one is saying that, again, that an institution shouldn't work with the student to try to mitigate any harm that they may have sustained, even when the act or omission or the thing at issue was innocent or inadvertent. The question here is only whether or not it should be the basis for the discharge of their loans. And what this administration is saying is it's not appropriate. We don't think it's appropriate to discharge loans if a school inadvertently or innocently made a mistake. That's what they're saying. So what they've done is they've created a misrepresentation standard here that requires that whatever the act or omission was committed by the school, that the school made it with knowledge of its being false, misleading, or deceptive, or with a reckless disregard, right, for the truth. So maybe they didn't know, but, this is sort of a step down from intent or knowledge, right? There was a reckless disregard. They should have known, okay? So the department in BDR-3 gives lots of examples of what might be deemed a misrepresentation. You should review these in detail, right? And most of them work the same way. So in all of these examples, the department is essentially saying if there's a material difference between what a school represented or a vendor represented to a student, and this caused harm, right, and what was actually true, then that would be a misrepresentation, right? So if there was a material difference between what you told a student or borrower about your licensure passage rates and what was the truth, misrepresentation. Same thing for employment rates or institutional selectivity rates or rankings or admission profiles, specialized programmatic or institutional certifications, transferability of credits. These are all hot topics, and these are all concepts and data points that are important to borrowers and students, right? These are things we tell them when we're trying to persuade them that this is a great institution for them and they should enroll here and spend money here and be educated here. And the department is saying these are important things, and if there's a difference between what you're telling them, a material difference between what you're telling them and what's true, that's a problem, right? Now, I've got some boxes around 4 of them. The ones that don't have any color, I've got outlining, right? The ones that don't have any outline are they're pretty much just straight up, the standard is there can't be a material difference between, what you told them and the truth. For the 3 that are in yellow or outlined in yellow, there's a little more nuance, and you should look at those a little more closely. And then for the one in red, I really just wanted to call this out. And the financial aid professionals, when we were at the table in NEGREG, called this out too. And I thought it was a very fair point. They said, look, what you're saying is if there is a material difference between the availability or nature of financial assistance that we represent to a borrower, for example, at the time of enrollment, is going to be available, and what they actually get on the back end, that could be a misrepresentation. And the financial aid folks threw the flag, right? And they said, well, wait a minute. All the time, we will provide stuff with, a tuition proposal or projection or what have you, some sort of award package, and their circumstances will change. Maybe they get a new scholarship. Maybe some additional grant becomes available. Maybe, Uncle Tim gives them $10,000 to put towards their tuition, whatever, but it impacts the aid that they're going to get, the availability or nature of that financial assistance. And, the department kind of heard that, but they didn't change the legal standard. They do in the preamble say, look, if a school could demonstrate that the information they gave prior to enrollment was accurate based on, all the other data they had at that point in time, well, that's meaningful, and that would probably mitigate a claim of misrepresentation, or certainly would go towards mitigating that. But they didn't change the standard in the law. So, for the financial aid folks out there, first of all, you may want to look more closely at this. I would suggest you all look at all of these, but you also may want to think about the disclosures that accompany, those grant or award letters that you're sending out in advance, or not in advance of admission sometimes, but, contemporaneous to their admission and orientation. Let's talk about that concept, provision of educational services. Something else we talked about when we were at the table is we kept saying, department, again, this is such a broad concept. You say that the act or omission has to relate to the provision of educational services, but if you're an institution of higher education, what doesn't relate to the provision of educational services? It seems like ostensibly that could be everything. So the department here said, well, it refers to the educational resources provided by the institution that are required by an accrediting agency or a state licensing or authorization agency for the completion of the student's educational program. This seems like a very squirrely concept to me, and it's probably one that, it's good that the department has tried to put some box around it, and it should make it easy to exclude certain things, right? So if you're providing, non-educational resources, you got a new gym on campus, or, you put in that new student sauna, whatever. I mean, you should be able to argue, well, wait a minute, those aren't educational resources required by the accrediting agency or state licensing entity. But when you talk about, sort of career services, I think there could be other types of student services that your creditor might anticipate that you are providing that could get wrapped up here. So I'm not exactly sure where the line in the sand is to be drawn. Again, it's good that the department is at least acknowledging that there are services and resources that are outside of this scope, and institutions will have an opportunity to try to highlight that. If somebody, says their loan should be discharged because you didn't get the new student gym built in time and fitness facility that you said was going to be there, okay, maybe that falls outside and isn't a basis to discharge loans. But this is kind of a squirrely standard, and I think over time schools and the department are just going to have to work through it. Financial harm. So the department has said, look, in addition to establishing that there's a misrepresentation, right, and that it satisfies these other standards, I mean, it can't just be some sort of abstract concept of detriment. I mean, students need to show that they actually suffered financial harm if they want us to discharge their loans. And by the way, that has to be monetary loss. So the department in BDR-3 articulates some exclusions, things that they would not consider monetary loss. For example, damages for non-monetary loss, like aggravation, emotional distress, or importantly here at the end, opportunity costs. Because, you'll have students say, well, I wouldn't have come to this school but for this representation. And the department is saying, well, okay, but you've got to go further than that. You can't just say that you would have had other opportunities that you didn't pursue. The act of taking out a covered loan. So consumer advocates and borrowers and others on the other side of the table felt very strongly that the loan itself and the fact that you took out the loan should qualify as monetary harm. And the department has said, no, the act of taking out the loan itself doesn't qualify as monetary harm. And there's more discussion around that in the preamble as to why they landed there. Loss that's predominantly due to intervening economic or labor market conditions. So, okay, if there's a recession and everyone is impacted, you can't say that's evidence of monetary loss. Or if it arises out of the borrower's voluntary decision, for example, not to work. So if a borrower says, well, I graduated from the school, they made this representation to me, I graduated and I've made no money. They said graduates of the school would make X. That was a misrepresentation. And then the department says, well, have you attempted to work? I said, no, I made a voluntary decision not to work. Okay. Well, the department's saying then that's not evidence of monetary loss. Okay. Now, here are some examples that the department would consider valid examples of financial harm. Inability to complete the program because the school ceased offering a required component, okay, without an alternative. Periods of unemployment unrelated to economic recession. So everybody else is going gangbusters, and this borrower is not, despite having successfully completed your program. Inability to obtain employment when it was expressly guaranteed. Hopefully no one on the phone is expressly guaranteeing employment to graduates. If you are, we should talk on the side. A significant difference between tuition and fees represented and those charged. Okay, and that's another one that schools should pay attention to. So remember, these are examples of financial harm that are in the regulation, and one of the things that you can do, whether you're talking of BDR-2 or BDR-3, frankly, there are, and under BDR-2 actually, the department also has some discussion in the regs and in the preamble about the types of activities, whether it be recruiting activities or other things that they consider sort of evidence of aggressive marketing or, foul play, et cetera. I mean, you really ought to look at those examples if you haven't already. Talk to your counsel. If you're one of my clients and you want to see them, talk to me and I'll put them together for you. You ought to look at these examples of financial harm because these are concrete examples of what the regulators think, are activities that they think are problematic. Same way with their examples of misrepresentation. And you guys want to know what those are, and then you want to have, sit down with your team and say, we want to make sure we're steering clear of any of these. Right? I mean, we don't even want there to be a question. And if we think we have a practice or protocol that could be misinterpreted, or if we think we need more disclosures or disclaimers or something, let's do that because we want to be certain that we're steering clear of any of these concrete examples that the agency is putting in its regulations. Claim exclusion. So this is the stuff the department has said definitely does not constitute a BDR claim, right, under BDR-3. And some of these, by the way, are present, if not explicitly, in the commentary or sort of echoes of these concepts exist in BDR-2 as well. A violation of the HEA or the BDR rules under BDR-1 or BDR-2. So in other words, what the department is saying is, look, a borrower can't say, hey, I saw that my institution got hit with a program review because they failed to timely return Title IV funds for 6 students, and so that's a basis for a borrower defense claim. You know, the department's saying, no, that's, you know, if you can't highlight a violation of the HEA or of some other procedural piece under the borrower defense rules, for example, as a basis for a borrower defense discharge, unless you can otherwise show that that violation would constitute the basis for a BDR claim. What does that mean? Well, wait a minute. What if in the program review the department hit you because they said you were guilty of a misrepresentation, right? So you got a program review out there, and the program review says you misrepresented your, you know, whatever to your students between period X and period Y. Well, okay, then a borrower could say, well, wait a minute. There was a misrepresentation. I was one of the people who was subject to that misrepresentation, and that's the basis for a borrower defense claim, misrepresentation, right? So it's not a de facto basis just because you violated a provision of the HEA. A borrower would have to show that whatever it was, that violation also still satisfied the claim standard, being a misrepresentation or, if you're under BDR-2, you know, breach of contract, misrepresentation, et cetera. If the borrower alleges a claim that doesn't directly or clearly relate to enrollment or the provision of educational services, although this should be, I mean, it's good the department has stated here, it is implicit in the definition of borrower defense claim under BDR-2 and BDR-3 for that matter. And then they give some other examples, though, and this is helpful. They say, again, personal injury, sexual harassment, violation of civil rights. But they also say the general quality of a student's education or the reasonableness of an educator's conduct. So this is like the classic education malpractice claim, right? So the student isn't alleging a misrepresentation. The borrower isn't alleging a misrepresentation. What they're saying is, no, you did what you said you were going to do. You were just lousy at it, right? I went to all the classes and the teachers were terrible, and I graduated and I don't feel like I know how to do X, Y, or Z, right? And the department's saying, well, that's, you know, that's not the basis for a borrower defense discharge, right? Informal communication from other students, academic disputes and disciplinary matters, and here under BDR-3 they make quite explicit breach of contract, unless that breach of contract also constituted a misrepresentation, and you could show that it satisfied the misrepresentation standard under BDR-3. I know this is very lawyerly stuff when you get into sort of these claim standards, but this is good. I mean, conceptually what the department here is saying, and by the way, I would argue it's good for everyone, borrowers and schools, because what the department is saying is, look, this is the box. There's stuff inside the box, and that's the basis for a borrower defense claim, and there's stuff outside the box, and that would not be the basis for a borrower defense claim. And before, you know, borrowers or schools or the department, before everybody engages and spends time and effort and money to try to get through a claim process, let's just try to have some additional clarity around what goes in and outside that box. So how's the process work? I mentioned earlier it's simplified. Borrower submits the claim and supporting documentation. All right, within 60 days, the department sends to the school that claim and all the supporting documents, including any other evidence in the department's possession. So remember I told you they can take into account those other claims and the program review, anything else they've got, but they have to send it to the school so that the school can see it. And a waiver permitting the institution to use the student's education records in its defense. So part of the application, the new borrower defense application, post-July 1, 2020, one of the things a student has to do, or borrower, when they file the application is they have to say, as part of that, I give the school the right to use my education records to defend itself, because otherwise you could have a FERPA concern. And the department gives the school, again, 60 days to respond. So the department has to provide the school with information within 60 days, and then the school gets 60 days. If the school responds, the department then sends the borrower the school's response and any other evidence in the department's possession. So you see the parity here. I mean, the idea is you want to give both parties all the stuff that the department's looking at so they can evaluate it and have a fulsome opportunity to respond. And they need all the evidence to do that, right? And they give 60 days to everybody at each stage. The department gets 60 days to reach out to the school gets 60 days to respond, and then the borrower gets 60 days to offer a final reply, in which case the department provides the school with the copy of that final reply. And then there are no further submissions unless the department asks for it, right? So the borrower files the application, school gets to respond, borrower gets one more chance to reply, and the school gets a copy of that reply. Then a staffer, so we don't have an administrative law judge. Again, this is all still being done at the staff level, probably primarily just for practical reasons. And we had this conversation during NAGREG, and the department just said, look, we can't have an ALJ. You got 300,000 of these things on back order already. We're going to have more in the future. We don't, we have a handful of ALJs. It just won't work. We got to have staffers who can do this stuff. The staff reviews all documentation and issues a written decision notifying the parties of the outcome, outlining the reasons for the decision, and there is no appeal. So under BDR-3, there is no appeal process. After the written decision comes out, the department, in accordance with time limitation, 5 years we mentioned earlier, can initiate a recovery action under Subpart G. Okay, so it's pretty good. Pretty good. I mean, it's simpler. You have fixed time frames. It's easier to understand, I think, and there's value in simplicity when you talk about processes like this. Still some things to note. I mean, there's no independent hearing official. So you still have a staffer, and that means if you get, any time, I won't say it's subsequent administration, it's a little unfair. I mean, all of us have our prejudices, whether that be prejudice against schools in a certain type of sector or just schools in general or against borrowers, and the idea is when you have hearing officials, they're independent of the department. Even though they're in the department, they're not part of that FSA infrastructure, and that they would be more independent and more capable and practiced in handling these types of adjudications. You're not going to get that. Whether it's BDR 1, 2, or 3, you're going to have folks just sitting down the hall, and they can be subject to peer pressure from potentially from political appointees, from others, from one administration to the next. They may come and go, and that's just the reality, right? So it doesn't matter. All these claims, BDR 1, 2, or 3, are going to be managed by staff, unless it's a group claim under BDR-2, right, in which case it does go to an ALJ. There's no voluntary resolution process on the front end. I'll give props to Chris DeLuca, who was also a negotiator and at the BDR-3 NEGREG said, the Office of Civil Rights for Title IX issues has this voluntary resolution process on the front end where the parties can try to work it out before going to an official claim process. Why not do that here? The department ultimately said, we just don't have the resources. I liked it. I thought it was a good idea, and I was sorry not to see that put into place and I think it should have been put in place BDR 1, 2, or 3. Shouldn't matter, right? And by the way, I should also say there was support for that idea as long as it was done in a certain way from all parties at the table. It was just a lack of resources that seemed to be the concern. There's no appeal opportunity for either party. Right? Things that I think are probably better, there's no group process. I mean, I really feel like, and I think this is the argument of the department, and certainly it was the argument when we were at the table in NEGREG, the statute contemplates a right for individual borrowers to assert a defense, and the group claim or sort of class action process gets away from that. There's no distinction between open and closed schools. I think that's good. I think it's good this process is simple, and whether you're an open or closed school, you have the same procedural rights. Guarantees the right to review and submit documentation to both parties, which is excellent, and guaranteed timeframes for responses for both parties, which I also think is excellent. There's a revised claim form, and this is good. I mentioned this earlier. The department is asking for more from borrowers when they file, asking them to provide more information, asking them to take on a little more in the way of responsibility. And this is all spelled out in the reg. BDR-3 time limits, I mentioned this at the outset. So for borrowers to bring a claim, 3 years from the date the student's no longer enrolled at the institution. For recovery actions, the department has 5 years from the date of the written decision. There's one carve-out for claims. The department can extend the claim period or reopen a claim, even under BDR-3, to consider evidence that was not previously considered, but only if there's a final non-default judgment on the merits by a court that has not been appealed or that is not subject to further appeal and that establishes a BDR-3 misrepresentation. So this is a pretty narrow carve-out for reopening or extending that claim period. Relief limits, I just wanted to mention here, we've been talking about discharge of loans and this whole process, and it's important to emphasize whether you're talking about BDR 1, 2, or 3, in all cases, the amount of relief cannot exceed the amount of the loan and any associated costs and fees. The other thing, and this is a really critical concept to understand, and I don't think a lot of borrowers or schools understand this, that relief that the department's willing to grant will always be reduced by the amount of any refund, reimbursement, indemnification, et cetera, or any other financial benefit received by or on behalf of the borrower that was related to the borrower defense to repayment. So just to give you a really easy example, I mean, if the state has a tuition recovery fund and the student filed a claim and was able to get fully reimbursed for everything they paid, they don't then get to turn around and discharge their loan, right? At that point, they still owe the department, and the department makes that very clear in the regulation. They say, look, you don't get to double dip. I mean, we want you to be whole, but if you got all your tuition repaid by a state tuition recovery fund, then you're going to have to use that money to pay back the loan to us, right? You can't make money on the misrepresentation. Just finally, and then we'll hit questions. We do have a higher ed webinar series. This is not part of it. This is sort of a special one-off because of the borrower defense rule came out. Our next one coming up actually is in October, and we're going to be talking about merging institutions of higher education. And then in November, I'll actually be back probably to talk about the new state authorization rule and some of the things around that we expect to see between now and November 1st. All of these are on demand. I mentioned that at the outset. You're very welcome to listen to them anytime. They're available on our TCLE page, and you can see we've already got the space set up for both of these, and the one for today should be available probably by close of business tomorrow. Regulation is our blog, so we write about a lot of this stuff too, and you are very welcome to check that out. And then finally, we occasionally put out resources for folks, and I just want to make sure if you need something, if we've got it out there, and that you at least see it so that you'll have it if you think it might be useful. So one of the things that I'll talk about tomorrow is our borrower defense reporting guide, and this is under the current rule, which will continue to be in effect until July 1st of next year. So you do have some reporting obligations under the current rule, and we have this little nifty guide that we put out that goes through those. And then also sometimes we'll put out things like the document C on the right, which was under for gainful employment, was a model early implementation document that schools could use. All right. So 126, seems like the 90 minutes in this case made sense. Let me see if I can get through some questions. All right. Let's see. All right. As of December 31st, 18, over $500 million worth of loans have been discharged by the department according to its record. To what extent and how systematically is the department pursuing recovery actions against institutions? So my impression right now is that most of the discharge that's occurring, and there was actually a note today in Inside Higher Ed about the department's decision under the automatic closed school loan discharge provision, which I'll talk about tomorrow, to discharge a bunch of loans that were from students who had attended the ITT schools. But most of the discharges, I think, that are happening to date are closed school loan discharges, right? Because under BDR-2, there is a provision that says after a certain period of time, students who qualify for a closed school loan discharge, those loans will just automatically be discharged without regard to whether they put in an application or not. And what's interesting is, in the sort of two massive school closures, Corinthian and ITT, but also in a lot of the other activity you've seen both in the for-profit and private nonprofit side where schools have been consolidating or closing or going out of business, where locations have closed, it is vastly easier. I mean, that's an understatement. It's incredibly easier for the school, for the department rather, to discharge those loans based on a closed school loan discharge. Even if the borrower also has a claim for a borrower defense discharge, right? So they say, well, my school did something and I should have my loans discharged. It's just so much easier for the department to say, oh yeah, but your school closed and you were enrolled within 120 days of when the school closed, so we will just discharge your loans pursuant to a closed school loan discharge because you clearly qualify for that. My impression is that the department is discharging, working to discharge, and is discharging millions and millions and millions of dollars of loans under the closed school loan discharge process. But I believe that under the borrower defense discharge process, there's still a lot of hang-up, right? And they came and addressed us when we were at NEGREG, to talk about it. I mean, there's some litigation out there that's tying some of this up, but also it's just so hard for them. They talked about they get a lot of applications where it's hard to even understand sometimes what the allegation is, because as you can imagine, you got 250,000 applications, some of those are going to be done very well. Maybe a borrower got help from a legal aid entity or consumer advocacy group, or is just very capable and competent. And some of those are going to be handwritten and very hard to even read. And that's just the spectrum, right? And the department said, look, we have, several thousand that it's hard for us to even understand what the allegation is. And that's part of it is, and then the other part is this complexity around state law. So even setting aside the online context, you got a student who says, well, the school did X and they did it 6 years ago, and I'm, from the state of Y. And now the staffer has to go figure out, okay, well, what were the laws, consumer protection laws around misrepresentation that may have been in place in that state 8 years ago? And it's just, I know this administration has expressed great frustration that, they inherited this, couple 100,000 claims, and there's tremendous political pressure on them to process the claims, the bar defense claims, but they have noted it's extremely complicated and hard to do. Right, which is why, again, they're defaulting to closed school loan discharges, because their feeling is, look, if we can discharge the loans accurately, with merit, discharge the loans based on it being a closed school loan discharge, it's just so much easier to do than to get into this issue under BDR-1 or even BDR-2. So right now, my impression to answer, again, the question is just that I think that they're kind of stalled on the bar defense side, but they're trying to make as much progress as they can getting through closed school loan discharges instead. Let's see. So if an institution provides an estimate to the student on the day they complete their FAFSA, if the student is selected for verification, that estimate can vary greatly. Is that a potential issue under BDR-3? Yeah, great question. So that goes back to the concern that the FA professionals raised at the table. Was we give them these estimates early on, which we're asked to do, and then those can change based on, to your point, even the verification of data. My advice is I think schools are going to want to be mindful of this. I'm sure if you ask someone at the department right now this question, they'd say, well, of course not. I mean, but the problem is, you don't know if that staffer is going to take the same view as the staffer who's there 2 or 3 years from now, first of all. And, whether a staffer gives you comfort or not, I mean, I'm always glad when the department says something like that. But at the end of the day, it still falls back to what the law says. And the problem is the way the law is written, it doesn't make that clear. So I think, frankly, that institutions of higher education and regulated communities should push for some sort of formal written guidance from the department around this issue, and some clarity that they could hang their hats on, if it came up. And the other thing is, I would just include some disclaimer language to students, making very clear, if you don't already have it, that estimates that are provided are based, on the data that is available to the institution on the day the estimate is made, and that, changes can occur if changes in the student's circumstances or the data otherwise changes. And I think that's about the best you can do, given the way that the BDR-3 rule is written. And by the way, it's not just BDR-3. I mean, yes, this is sort of where this has come up, and they've provided this example, but there's nothing that could prevent a student from arguing that some big swing in what you told them they'd get and what they got was a misrepresentation or a breach of contract under BDR-2. Let's see. All right. So as of April 1st, similar question, looks like there are about 158,000 pending claims for discharge. Yeah, that's a good question. So similar question, how do they get through this in a timely fashion? And what does a borrower do while their claim is pending? Well, that's the big issue right now, right? I mean, I don't think the department has the ability to efficiently adjudicate that volume of claims for all the reasons previously articulated. And it also doesn't help that, as a lot of folks on the line may know, both FSA and especially FSA, but other elements, Office of Civil Rights of the Department of Ed, have seen significant staff reductions over the last 3 years. So that's not making life any easier, for them to get through all of these claims. I mean, I think it's tough, and I think in the interim, I don't think there's a statute of limitations running on the borrowers, but unfortunately, I do think it means that borrowers aren't getting relief. I mean, because you have to think some of those claims don't have merit, and some of them do. And if it has merit, and a student really should have a borrower should have their loan discharged, it's an unfortunate reality that you've got a messy claim standard that's out there, particularly under BDR-1, that's so hard for the department to execute on. You've got cumbersome processes. You've got all the political overlay. I will be the first to say that the folks who at the end of the day suffer from all of this are the regulated community, and that includes the borrowers and the schools, right? When you have these rules that are going back and forth, and I mean, just look, you've got three claim standards and 2 different processes that are all going to be in play simultaneously. What a headache for everybody involved. But that's unfortunately just for where our politics have landed us, I'm afraid, which is not new to the folks on the other end of the phone. I know I'm telling you things you already know. So that was our questions. Hey, thanks to everyone for tuning in, and if you can endure it, I hope that you will tune in again tomorrow when we talk about the financial reporting in particular, and then also spend a little time on closed school loan discharge, false certification discharge, and I'll just hit briefly on pre-dispute arbitration agreements as well. Otherwise, have a great afternoon, and we'll talk to you soon.